Okay.
Hello, so my name is Liza, I'm from Biscoe Solicitors, and I've welcomed along today Ian Wheaton from number 18 Chambers. So this week, landing in my inbox, I had an email from number 18 detailing private FDRs and what they involve, and I thought it was really useful and might be really useful to anybody that was already going through financial proceedings. So Ian has been kind enough to come on today and have a chat with me about private FDRs. If we could start, Ian, if you could just explain what an FDR is for anybody that doesn't know and where that would fit within divorce proceedings.
Yeah, of course. An FDR means a financial dispute resolution appointment, and I've emphasised the word appointment, not hearing, for reasons I'll explain in a minute. And it's something that happens before the final hearing, and it's an opportunity. It's after the parties have completed their Form E, so that we've got all the financial information in front of us and would be available for the court. And it's an opportunity for the parties and for a court to see what the issues are, see how they can possibly be bridged, and more importantly, or as importantly, in order to enable the parties to avoid a final hearing, to see if the court can assist the parties in coming to an agreement, coming to a conclusion. Because it's much, much better to take ownership and to be in control of the outcome of your proceedings than it is to put them into the hands of a complete stranger, being the final hearing judge, who's never met you before, doesn't know what you're like, can only go on the basis of the evidence that she or he hears on the day. So really only gets a snapshot of the financial circumstances and any major relevant incidents or things that have occurred over the years, but is in reality a stranger who will only have seen your case papers a week before and will only have very limited information, depending on the stories that are told in the final hearing in order to make a decision. So what an FDR is an opportunity for parties to come to an agreement. They may not like it, but they may not like the outcome of an agreement. But a judge once said to me, and I think this is common amongst a lot of judges, is that in a final hearing, if you can't reach an agreement in an FDR, a judge's job is to make both parties unhappy, because quite often both parties go away with something different to that which they were asking for in the first place. So it's not a question of winning or losing, but it's a question of both parties being, perhaps because the judge has had to spread assets around more thinly than the parties imagined, both parties can end up disappointed. So an FDR is a really good possibility, and a judge will give you an indication to enable you. So they will say, if I was hearing this as a final hearing, they'll give you an indication as to what a judge is likely to do at a final hearing to inform you or inform the parties as to the best outcome that they're likely to achieve and the way that they can go about it without having to go through the pain, the emotional pain and the financial pain of going to a final hearing.
And in my experience, most parties will reach an agreement at or before the FDR. Is that your experience as well?
Well, I get pulled in when the parties can't reach an agreement, but hopefully, the ambition is to reach an agreement at the FDR or before the FDR, or possibly afterwards, because just because you can't reach an agreement at the FDR doesn't mean you can't still negotiate. And the key word is to negotiate and to maybe cross. I think red lines are or used to be a feature that we heard quite a lot, but cross some red lines and give up some things that you may have considered to be sacred in order to reach an agreement. But yeah, the emphasis is upon reaching agreement rather than the small percentage of cases that actually make it through to a contested final hearing, because that's just not a good situation to be in. If you can avoid it realistically and sensibly, I say that because any agreement that you reach at an FDR must be approved by the court, and the court applies the same factors, the Section 25 factors of the Matrimonial Causes Act. It applies those same factors to the outcome of a negotiation at an FDR stage as it would at a final hearing stage, to make sure that the agreement that the parties have entered into is one that can be sanctioned by the court.
So ordinarily then, an FDR would be one of the 3 hearings that we have within contested proceedings in the court. So what's the difference with a private FDR? How does that work?
Well, in a private FDR, instead of having a judge who would give you the benefit of their experience, you get somebody like me who's been involved in family law for a very long time, it feels like, but somebody who has experience of the outcomes of cases and the way that the courts would apply the Section 25 criteria. And when I talk about these criteria, these are the statutory matters that the court takes into account, such as the parties' financial needs, any contributions they've made, and the list that is set down in the statute. And so you get the benefit of somebody who doesn't have a position in the case, so then I'm neutral, and we're able to tell you fairly accurately what, if the case was before a judge, what a judge would be likely to do in order to dispose of the assets between the parties, or to divide the assets fairly between the parties. And one big issue is that a private FDR can lead, and we'll come on to this in a short while, but it can lead to a binding heads of agreement that you can reach, and you can bypass the court system up to a point, because any draft order that comes out of the private FDR must be put before the court for a judge to approve it, because, as I said earlier, if the parties reach an agreement that isn't sensible or isn't workable, then the courts are less likely to endorse that as being satisfactory. So it's not like a contract. You don't reach a contract with the other party, because everything is subject to the court's discretion, and everything that you could agree must be approved by a judge when approving a consent order that we would send to the court after you've reached agreement.
So why would somebody, what are the advantages of doing a private FDR, and why would somebody want to consider doing that over just continuing with the proceedings that they've currently got?
Well, parties will have already been required to mediate before they get to the court stage. And so it's a continuation of keeping negotiations going. Because clearly, when you've got two people who have been married for a significant period of time, have children between them, and they've got a number of assets to divide, they are the people who know that situation best. And it's to enable them to, if I can, keep proceedings out of court, or keep proceedings out of any further court hearings. And also, with the current lockdown situation that we've got, the courts have had to take a number of cases out of the court list over the last month or so. And there was already a significant amount of court delay involved or inbuilt in the system. And consequently, you may have to wait a number of months from the first appointment stage to get to the FDR stage. And so in order to enable people to try and resolve their differences sooner rather than later, they can engage in a private FDR. Once you've completed the voluntary disclosure in the form of the Form E, you can engage in a private FDR, and you can avoid, hopefully, if you can reach an agreement, you can avoid the current lockdown situation that we're in with the courts. And I can predict that when the lockdown ends and the court needs to relist all of the cases it's taken out of the list already, and by the list I just mean the court diary. And so when they relist all these matters, there's going to be significant delay, unfortunately, in having new matters come through the court system. And so delay could be a major feature. And if we can have some way of avoiding that delay and avoiding the emotional upset that goes with being in protracted proceedings, as well as the financial aspect of it, that must be a good thing for parties who are able to take ownership of their solutions.
And at the moment, we're obviously all stuck at home. These private FDRs, they can be done via Zoom video conferencing. Absolutely.
We can carry them out remotely or Skype for business. Ideally not on the telephone, but if push comes to shove, I have conducted a full final hearing on the telephone recently, but ideally not on the telephone. But yeah, we can certainly carry them out remotely, and we can engage people in a way that wouldn't necessarily have been the norm prior to this situation, because we are finding new ways, with everybody else, we're finding new ways of working. And if we can offer anything remotely, we will.
Yeah. And I think you touched on this earlier, but if the parties reach an agreement at the private FDR, what then happens as far as getting that agreement to be made binding?
We draw up something called, oh, excuse me, we'll start that again. We draw up something called heads of agreement. And the parties you can sign as an indication of what you're intending to agree. So that's the great thing. You've reached an agreement, the pressure is off. And so we draw up heads of agreement. It's not a binding contract. Emphasize that now for the reasons that I've already touched upon, in that the judges in court will approve or not approve any draft consent order that we send in as a result of the heads of agreement. So we reach heads of agreement. This can then be reduced to a draft consent order, which can be sent to the court for the court's approval. Now you may think, well, what if I agree to something? What if we have this private FDR, we reach an agreement, but then my other half decides to withdraw from it or resign from it? And then, unsurprisingly, there have been cases where people have tried to do this. On the whole, provided there hasn't been any issue with material non-disclosure or any other issue that may affect the validity of the agreement that's been reached, so provided everything is upfront in the way that we would hope that it would be, on the whole, the courts have considered that the fact that parties have entered into a heads of agreement, and they would want a very good reason why one person says they should not be bound by it. So there would need to be a significant change of circumstances or another good reason, which currently escapes me, as to why that individual shouldn't be bound. So the courts are usually in a position to endorse the agreement the parties have made. And that brings me back to the issue of it must be a realistic agreement. It can't just be one party rolling over, to coin a phrase, for the benefit of the other one, because that won't necessarily be approved by the judge when we send in a draft order for the court's approval. So they are binding, or can be made binding, in the way of the heads of agreement. Some people have tried to argue that they are entitled without prejudice, which means that they wouldn't be put before a final hearing. And I'll come on to that when we talk about what we can't reach an agreement. Yeah. So it has been argued in the past that these heads of agreement are not able to be put before a judge at a final hearing. But the Court of Appeal has been fairly clear on that, and that the parties must show a good reason why they don't intend to continue with the agreement that they reached at an FDR, whether it's a private FDR or an FDR in court.
Okay, perfect. And what if they don't reach an agreement? So they go along to the private FDR, an indication's given, and one or both parties still isn't happy to reach an agreement. What happens then? Well,
unfortunately, people can't always reach an agreement. And if that happens, then you would carry on with the court process to a final hearing. You could, if you've conducted a private FDR at some stage where you've started proceedings and maybe you've had the first appointment, so you've had your questionnaires and you've responded with the answers to the questionnaires, you may ask the judge to proceed straight to a final hearing on the basis that you've conducted a private FDR. At the final hearing, it's vital to remember that the private FDR that we carry out is what's called without prejudice. So it's the whole point of an FDR is to put cards on the table, say, this is what I would like to settle at in order to resolve matters. But if you can't reach an agreement, then the discussions in this private FDR, or the court FDR for that matter, would not be discussed before the judge at the final hearing, who would be a different judge to the one that carried out the court FDR, if that's what you had in the first place. And obviously, as the person carrying out the FDR, I wouldn't be a lawyer representing either party, because once a person has carried out an FDR, they would, not as a lawyer, but as a party or as a person seeking to assist the parties to reach an agreement. But once you've carried out an FDR, you couldn't do the final hearing or couldn't conduct the final hearing, simply because of the fact that you know the without prejudice position of the other side, or of both sides.
Perfect. And so finally then, obviously you've been dealing with cases like this for a number of years. So what advice or snippet would you have for anybody that's currently going through financial proceedings, particularly whilst we're in this sort of lockdown situation?
Okay, well, the lockdown situation, as we all know, as we hear every day on the news, is unprecedented. We hope that it'll be concluded reasonably soon, but how long that may be as long as how long is a piece of string. And so there is a significant level of uncertainty, unfortunately, amongst couples. And you see in the media of people with difficulties, perhaps even living under the same roof, separated but within the same property in lockdown. So if parties can speed up the resolution of their differences, of their disputes, if they can do so in a way that is measured and properly carried out, then that has to be a good thing. There's also the cost aspect, because if you go to a court-conducted FDR, the judge will always remind the parties, usually looking over the shoulders of the lawyers and talking straight at the parties. The judge will always remind the parties that whatever their costs are up to the point of the FDR, if they go to a final hearing, they're going to at least double, because the work that's carried out is significant in the preparation for the final hearing. And so, yeah, the cost aspect, if you can resolve matters reasonably soon and reasonably cost efficiently, then that must be a good thing for parties. The really important thing coming to any voluntary FDR is to come with an open mind to having a settlement. Because if you can't own the settlement that you have with your former spouse, then you run the risk of not only having months of delay perhaps, and the emotional hurt and unhappiness that goes with that. The amount of weight that is lifted off of people's shoulders when a financial remedy proceedings are concluded is enormous. But you must want to negotiate a settlement. Otherwise, you may be engaging in a pointless exercise. If you want to go to an FDR to prove that you are right, or to prove that somebody has done something that they shouldn't have done, then that probably isn't the reason to go to an FDR. You go to an FDR in order to want to settle a case, and in order to want perhaps to give up some aspects that until then you've thought are things that you simply cannot go back on. But it is essential that people come to an FDR with an open mind in order to be able to resolve the issues that they've got with their former spouse and for the benefit of the family. You need to have a holistic view, because if you have, as I said earlier, if you have red lines that parties simply do not want to cross, historically I've had cases involving cutlery sets, which are clearly very important to the parties individually, but to hold up a financial agreement over a cutlery set, even when it was suggested they could have half each, didn't cut it, and we had to go to a final hearing, at which neither party got what they wanted, and the judge didn't make a decision on the cutlery set. So they were still arguing over that. So you must have the genuine intention and the desire to settle. Otherwise, you would simply be going on one further step along the way to your final hearing.
Perfect. Well, thank you very much for taking some time out of your day today to have a chat with us about the private FDRs. It's been really, really helpful, some really useful information there.
My pleasure. Thank you. Thank you for inviting me.
Thank you.